Hello dear students, today we are going to discuss everything what we have studied during the semester. Today is the revision class and advertisement law was the course which was being offered by our university, Tashkent State University of Law for the very first time for the master students. And it has been an honor to explore different dimensions of this course from substantial point of view and from procedural point of view. We also looked into the national and local legislations as well as we explored different examples coming from different countries and international law perspective as well. And we really touched upon so many theoretical questions which are currently being explored by different scholars who are working on advertisement law. Said that advertisement law spread its tentacles on different other types of laws. For example, media law, journalism law, communication law, digital communication law, social media law. Sometimes intellectual property law is also included in advertisement law, or advertisement law as a part of intellectual property is being considered. Marketing is a full-fledged area of business, and marketing is important for all types of businesses, and that's why advertisement law comes as a substitutionary part of business law. When there is no specific course on advertisement law, people usually include certain portions of advertisement law into the business law modules. So when we talk about advertisement law, advertisement has its clear boundaries, because if you don't set the criterias for advertisement, there are huge chances that you will fall into different other sort of laws. For example, there should be a differentiation between intellectual property law and advertisement law. What are the criterias for intellectual property law and advertisement law? When we are talking about sales of goods, when we are talking about protection of the rights of the consumers, when we are talking about pure journalism, and we want to differentiate between journalism law and advertisement law, certain things should be clear, and it comes from the national legislation. The national legislation usually set the criteria that what exactly advertisement law is. What is the difference between advertisement law? What is the difference between media law, journalism law, or digital communication law? Because nowadays, because of the digitalization, so many people are talking about digitalization. So many people are talking about social media marketing. Even some countries have introduced specific laws related to social media marketing. So the first theoretical question is to set the boundaries for advertisement law. What is advertisement or advertising law for our purpose? Then we discussed about the law itself, because majority of the class was coming from non-legal background and we had to define some of the basics things. It was a really trouble for us because not many colleagues from our class had a legal background. So we discussed about what is law and uh, how the law functions in law schools. And we said that there are two things: one is law and one is ethics. So we will talk about it as well. But there is a thing which is called as rule of law. Rule of law is when everyone follows the law, and rule of law has a huge history. Different legal scholars have talked about what the rule of law is in their understanding. So we discussed about that as well. And we said that if we talk about rule of people, when the people make laws, we usually talk about democracy, that in democratic governments, people has an opportunity to make laws for the other people. So we call it democratic governance. And then we have rule of man in certain countries, when single person makes new laws, and we usually call it dictatorship. And then there is another phenomena which is about absolutism of legality. It is about fundamentalism. Fundamentalism is that certain people think that the religious doctrine is the actual law. So absolutely certain things has been decided what are right or wrong, and usually the legal scholar call it as fundamentalism. So these were different approaches in terms of their jurisprudence origin. And if we talk about market oriented law, we discussed two approaches. One was liberal approach, which was laissez-faire approach, that the government should have minimum interference in the economic activities. It is about liberty of business, and we have seen that in modern capitalist economies, usually this philosophy is being applied, that government has minimum interference in the business, which means that people are allowed to buy and sell whatever they want. And on the other side, there is a Marxist approach which has become classic, and many post-Soviet countries are following this Marxist approach, which is the total control of the government, means the resources should be equally distributed. Government should take control of the market, and government should see that there is a perfect balance between the demand and supply, and proletariats and bourgeoisies, they are following the laws which are usually established by the government. So this is the market dimension of the law. Then there is a distinction between public law and private law. So public law, in very simple words, we discuss this in detail. The public law is the law which regulates the relationship between the government and the individuals, between government and the people. And the private law is the law which regulates the relationship between people, and government seems not interfering into the matters involving two types of people. So in case of violation of public law, there is a criminal liability, and in case of private law violation, you have to provide the compensation if you are doing the damage to the other party. And then there is substantive law and procedural law distinction. Substantive law means uh, the the uh, the substance of law, or what exactly this law is dealing with, and the procedure means how it should be dealt. So if I have to give an example, I will say that the procedure is, whenever someone commits a crime, police will come, police will you know take this person to the court will give him some sort of punishment. This is a procedure, okay. And if we talk about substance, so substance is that if you will do some crime, you will be punished. This is the substance of a crime. And similarly, common law and statutory law was something which we saw in detail. I will talk a little bit about it in revision lecture as well. So the common law is the law which is mainly followed by the British British and the former British countries, Commonwealth countries, USA and UK. And statutory law is the law which is mostly nowadays followed by the former Soviet Union and Russia and France and so on. And then there is a differentiation between international law. International law regulates the relationship between two countries or individuals coming from two countries. And municipal law is usually the national law or the local law, which we refer as municipal law. So these were some important distinctions which we had seen during our lecture. Okay. And then there was a difference between law, morality, ethics, and religion. We spent some time on it, and we said that law, which is usually created by the state, created by the people, and morality is something which is created by the society. And most of the time, it is inside the person, and ethics is something which is created by the professional body for the legal purposes, and ethics is the demonstration of your morality. So these are some of the words which people usually confuse, but there is a clear distinction between. And there are three, actually there are many, but some of the main legal systems are common law legal system, which is mostly followed by UK and USA and the colonies of former colonies of UK. And then there are civil legal system, which is mainly followed by the Russia and the former Soviet Union. And then there is a Muslim legal system, or you can say that the religious legal system. Certain countries in the world, they are following the religious legal system as well, which is further divided into different categories. Canon law, for example, it is an example of religious legal system. Canon law, the law which is coming from the Bible law, coming from the Bible, Christianity based law. It is also a type of religious legal system. So, what are the salient features of the common law legal system? Advertisement law is being developed. Mostly the substance of common law, mostly the substance of advertisement law is being developed in the common law countries. So there are different salient features of common law legal system, and one of the main feature of the common law legal system is that it is based on the case. Judges decide the case, judges give the judgment, and this judgment becomes a new law. Civil legal system is mainly based on Roman German law. It is also called as Roman German law. So the law is decided in advance. Jurisprudence is clear about the meaning of law in the civil law system. Judges or the legislators or the legal scholars, they make the law in the codified form. So Uzbekistan or Kyrgyzstan, Kazakhstan, former Soviet Union countries, Russia, they mainly follow the civil legal system in which law is written in advance and there are different codes available. So whenever a legal issue arises, the judge will simply go to the book, because law is already written and the judge will follow what is written in the law. This is the civil law. Different sources of law in different legal systems, but the main source of law is the constitution of the country, then the legislation which is made by the parliament. Subsidiary legislation is made by the uh, individual organizations, you can say. And then the common in the common law system, you can say that the judges also make the law by passing different. If we talk about sources of law in civil legal system, the law main codified form of law is made in the parliament. Then there are tradition, journal principles of civil law. They are based on traditions or equity as well as sometimes they are really contextualized with the demand of that time, and they are written in the journal principles. So if we look into the civil codes of some of the countries, the first chapter is usually first chapter of civil code of many countries. It talks about general principles of civil law, in which some of the principles of civil law based on the equity has been mentioned. So in case you don't find any codified law, you can simply refer it to the journal. And we discussed about alternate dispute resolution. Alternate dispute resolution, as the name suggests, that if you don't want to go to the court, you can go for alternate dispute resolution. What are the mechanisms of alternate dispute resolution? There are different types of alternate dispute resolution. Mainly arbitration and mediations are being. So arbitration is a little bit formal. You have to engage the arbitrators. You have to go to the arbitration institution, and the judgment of the arbitration or arbitral award is binding on the parties. On the other side, mediation is little bit informal. For the mediation, mediator will try to involve and engage the parties and give them an opportunity to decide the matter. About some of the countries, which type of law they are following. Here you can see that common law is mainly followed by the Australia, Canada, India, Pakistan, UK and USA. French civil law and German civil law, it is being followed by Argentina, Belgium, Indonesia, Portugal, Turkey, Japan, South Korea. And Scandinavian civil law, they have their own version of civil law, which is being followed in the Scandinavian. So if we talk about, we thought that this definition is very comprehensive definition. In this lecture, we discussed about different dimension of advertisement law, and we said that advertisement is the non-personal communication of information usually paid for. So usually paid for means the information is somehow communicated to you by an information provider, or you can say it the advertising agency, or marketing manager or marketologist who gets salary from the company whose information he is selling, and usually persuasive in nature about the product, and they really try to convince you to buy the product or service or ideas by identified sponsors through the various media. So this is a very comprehensive definition. Advertisement is the non-personal communication of information usually paid for and usually persuasive in nature about products, services, or ideas by identified sponsors through the various. We said that these are the sense visuals which play a very important role in communicating the ideas to the individuals. Then we also discussed about consumer rights and the sales. Said that consumers have different rights. Previously, they were not that aware of exercising their rights, but nowadays they know that they have certain rights and how to exercise them. Different countries have provided different mechanism for the protection of consumer rights. In Uzbekistan, by that time when we were discussing this lecture, there was an agency for the protection of consumer rights which had its helpline as well. You can simply call to the agency if you have a complaint against the product and service, and they will definitely try to resolve this issue. So there are different rights of the consumer, and we talk about who is the consumer. A consumer is the person who has indicated his or her willingness to obtain goods or services from a supplier with the intention of paying for them. So he pays for the services and the goods which he is buying with his own intention. He deliberately makes a decision and then pay the money to buy these goods, and these consumers are being exploited. Why these consumers are being exploited? Because of the competition among the goods and service providers. There are so many goods and services in the market. Most of the time these goods and services are being offered by the companies who have uh, very tough competition among themselves. And then what happened that everyone wants that the customer should buy their product, and for this purpose they really try to exploit by hook and by crook. They want to sell their product and service to the customer, and while selling these product and service to the customer, sometimes they exploit the customers, and the consumer rights are clearly can be seen being. We discussed about business tort business tort, and unfortunately it is a common law specification when we talk about the jurisprudence of the tort. In civil law countries the tort is not very well developed, but there is an understanding of the tort law. So we discussed about the tort is a civil wrong and it is independent of contract, and when a tort is committed it is about you know it is about dissolving a dispute or resolving a problem among two individuals, and government usually is considered as a neutral party. So it gives rise to the civil remedy, which means that if you commit a tort you will not be liable to the criminal liability, but you have still have a civil liability. uh, Difference between crime and tort: in the crime government is the party, in the tort two individuals are party, and if you commit a tort you are liable, and if you commit a crime you are considered as a. Is a difference between tort law and contract law. In the contract law things are already being decided, things are written in the contract, and the liability evolves from the breach of the contract. On the other side, tort is something which is not pre-planned. You are going and suddenly you bump your car into someone else's car and you committed a tort, and obviously you did not plan for it, so now you will pay him the compensation, which is the tort liability. Tort liability and product liability, we saw that from the marketing perspective and from the advertisement law perspective. We saw so many examples when a tort is being, and we said that one thing is which is very common in advertisement. It is the intentional tort. So we can see that in certain as advertisement, we can really feel that the product supplier or the service provider is intentionally committing the tort, and we saw so many examples from the Uzbekistan as well. So the person who is accused is called as tort fesser, and it can be, if we differentiate between intentional torts are mainly of two types: against person and against property. So if we talk about advertisement, persons also have their marketing, they also have their image. And we talk about product and services or your property, they also have their. So if you commit an intentional tort against the person, it fault, or you can talk about false imprisonment in the businesses, we can see certain. And defamation, so defamation is both in case of persons and property. Nowadays you can see defamation, and we discussed about defamation in detail. There was a full-fledged lecture on appropriation, misrepresentation, wrongful interference, all of these things they taught. And uh, some examples of tort, we can say that false advertisement can raise certain claims with regard to the tort. And false advertisement is something which is very common, especially in the small and medium sized businesses. They usually rely on false advertisement because um, they really need to convince the customer to buy their product, and for this purpose they can do anything whatever they want, and usually they don't have ethical considerations. For example, couple of examples we discussed, that the marketing manager show a picture, and in reality this product is not like as it is shown in the picture. This is a type of false advertisement which can raise a tort issue. Or if there is no tort law, for example in the civil law countries, it can raise issues related to the civil law. Some of the types of deceptions, some of the examples which are mainly used by the um, product sellers are photo manipulation. When they show you one product but they sell you other product looks different than the image being shown. Hidden fees and surcharges, subscription charges. For example, you look into a packing and packing looks very attractive and very big, but the actual product is very small. Falsifying the quality and origin. For example, you buy a product and it says that it is made in USA, but in reality it is made somewhere in China. Misleading health claim is very common in the medicine and the supplements, and so many products are available which claim that they will heal your body, but actually they don't do this. Puffing means it shows the product look very good, but in reality it is not. And different terminologies have developed. For example, organic or sustainable, uh, long lasting, but these are just terminologies. And incomplete comparison, for example, best or better or 99%. Sometimes they write that this soap will kill 99% bacteria and so on. All of these things, they are in incomplete comparisons. And misleading illustration, false coloring, and angel dusting, all of these things, they are different types of. Sometimes it happens, actually it is happening everywhere. Bait and switch, you look into the advertisement and advertisement say that 50% off, but when you go to the shop and you ask them for the 50% off, they say that sorry, the 50% off is no longer valid. This offer was valid until yesterday. Or sometimes they, you know, give you one product which is very cheap, but you have to buy another product in order to get this product which is very cheap, but you have to buy another expensive product in order to get benefit of this offer. So this is bait and switch type of. Defamation is very common in advertisement law. Most of the issues emerging from advertisement are related to the defamation. From legal standpoint, there are two types of defamation: libel, when defamatory statement is in writing, someone writes something about you, or about your product. And the other type of defamation is slander, when someone is saying something wrong about your product or your personality or about your. We also discussed about ethical consumerism. Ethical consumerism is the idea that it is not always the business who should be responsible or ethical. It is also the responsibility of the consumers to be ethical. And for this purpose we discussed about the idea of dollar voting. Dollar voting is the concept that the customers or the consumers have the power to select or reject a product. So if they buy a product, they keep buying this product, we say that there is dollar voting. Dollar voting means they are appreciating this product, or if they don't like this product, they can simply stop buying the product, and it is a type of ethical consumerism. uh, Ethical consumerism is the ethical purchasing, moral purchasing, ethical sourcing, ethical shopping. Green consumerism is a type of ethical consumerism. These are the examples of ethical consumerism. And the consumer ethics is an underable open specialization of business and marketing ethics, within which most publications have focused on bad rather than on good ethics. Okay. uh, we have seen that people really have the power to set the trend. So when the people set the trend, other people are forced to buy these products, which is a negative ethical behavior. Ethical marketing is the phenomena that the marketing by which companies market their products um, not only should focus on the product, but also they should focus on the benefit for the society or for the benefit of our environment. This is called as ethical marketing, when you are not only selling your product but also you are raising awareness that how this product is going to help the environment or our locality or our society in general. Corporate social responsibility, we discussed in one lecture about corporate social responsibility. Corporate social responsibility is the phenomena that the companies, they make money in the society. We ask them to make money, but in return we expect them to do something good for the society. Certain countries are becoming conscious about it. We say that they are ethically responsible companies or socially responsible companies, that they know their responsibilities towards the society. Corporate social responsibility is the phenomena that companies should do something. And we said that as per the social contract theory, we, the people, allow the companies to make money, and in return we expect them to do something good for the society. This is the idea behind the philosophy of responsibility. And we discussed about socially responsible consumer, socially responsible goods, socially responsible culture, socially responsible human resource management, and socially responsible production, and digital responsible corporations, that how the companies are handling your data, how the companies are using the data, how the companies are monetizing the data for the purpose of advertisement as well. For example, we don't know how much data is being collected in our country, but Amazon, for example, or some other companies, they are very sophisticated in collecting the data. Just imagine that after a couple of years, when you will have your grandchildren will be receiving a message from a restaurant, and this message will be saying that, do you love your grandfather? Your grandfather used to come to our restaurant. Your grandfather's favorite dish was this dish. So if you love your grandfather, come to our restaurant. So the data which is being used by the companies, or which is being stored by the company, will be monetized in future. And that's why it is very sensitive topic, that in the next couple of years, your, or maybe your next generation will have to suffer from the data which is being collected by the companies from your digital activities. So digitally responsible corporations, they sensibly use the data, and they know that this data is very personalized in nature, and that's why they should have an ethically responsible behavior towards the data. So our one lecture was about green marketing. Green marketing is an emerging means uh, the marketing or the product. Let's start from the product. Product should not harm the society. Product should not harm the environment. And also, instrumentally speaking, you should not be simply printing different pages. You should not be simply using neon lights or big billboards or distributing the pamphlet, because all of them, they harm to the environment. And different products, they claim to be green. We saw the words being used: biodegradable, composable, recycle, environmentally safe, ozone friendly. They claim about their products, but if the product is not biodegradable, then it is a problem related to the consumer rights violation. And in certain jurisdiction, it is the matter related to the advertisement law. For example, in America, there are certain things which we should avoid in green marketing. And one thing which we should avoid is greenwashing. That don't label anything green which you are not sure of being green. Yes, don't sell anything which you are not sure of being organic. For example, don't say that this is organic when you are not sure that this is 100% organic. And finally, ladies and gentlemen, from the examination perspective, uh, we looked into different cases, so many cases, and I said that you have chances of getting good marks if you solve your case by using IREG method, although it is coming from British universities. And usually the lawyer and the law students who deal with the common law system, they use these IREG methods. But since it is instrumental and it can be very easy for you to attempt the case law, it can be very easy for your marker to give you good marks. I suggested you to use the IREC method. So what was the was that first you will identify the issue, then you will identify the rule or the law. You can also give the examples of different cases which are similar to each other. Then you will apply the rule on the issue, you will analyze the situation, and in the conclusion you can write that which party you think is liable or guilty, or which party should give the compensation, and so on. So if you will attempt your question by using IREC method, there are chances that you will get marks which will be more if you will write everything in one paragraph. Okay, so this was all about our course substantive part. And of course there were so many cases which we have discussed in our tutorials. And I hope that you will get a chance to do revision of those cases as well before your final exam. And I wish you best of luck for your exam.